Welcome to another module of this comparative constitutional law course. This module is titled Why Compare? The Value of Comparative Law. My name is Badri and I'm a graduate fellow at the School of Policy and Governance at Azim Premji University in Bangalore. Over the course of this module, we will explore four interrelated questions. First, what is the relevance of other legal systems for India? Second, is it possible for us at all to compare different legal systems, or are we stuck trying to compare apples and oranges? Third, what are the motivations behind looking at other legal systems? And fourth, how may one be engaged in the task of comparison, or what are the methods by which comparison actually takes place? Let us start with the first part of our exploration of these themes. The Indian Constitution is inspired by and heavily borrows from diverse constitutional traditions. We seem to have borrowed from countries that no longer exist, like the Weimar Republic of Germany and Soviet Russia, from a country that does not have a written constitution, the United Kingdom, and other countries with steeped constitutional traditions, like Australia, Canada, and the United States. Our efforts to understand the unique coming together of these ideas in the Constitution of India requires us to broaden the focus of our interest and inquiry to the constitutional traditions of other countries and our specific place in it. Furthermore, Article 51 of the Indian Constitution enjoins the state missionary to foster respect for international law and treaty obligations. In the famous Vishaka case, the Supreme Court states that any international convention not inconsistent with the fundamental rights and in harmony with its spirit must be read into these provisions to enlarge the meaning and content thereof to promote the object of the constitutional guarantee. So what we see is that the Indian Supreme Court is not averse to the idea of using international law to facilitate and harmonize some of its reasoning. In a 2004 study, Adam Smith found that Indian courts had relied on or used foreign law, including international law sources as well as material from other foreign jurisdictions, in nearly a quarter of all their cases. Recently, in the National Legal Services Authority case, Justice Radhakrishnan found it fit to use international human rights principles at the core of his reasoning to clarify that the umbrella of anti-discrimination provisions in our constitution ought to extend to transgenders. Over 150 countries and other supranational entities can boast of adopting constitutions and incorporating provisions that include a Bill of Rights and enshrine mechanisms for judicial review. Some of these initial observations remind us of the continuing relevance of foreign legal material in our understanding of our constitutional culture. However, as Justice Singhvi reminds us in Kaushal, we ought not to apply foreign law blindfolded for deciding the constitutionality of a law enacted by the Indian legislature. Fundamentally, unlike other subjects that students of law are engaged in, comparative law is not a body of rules and principles, but rather a method of analysis and an account of the interrelationships between diverse legal systems and their rules. A self-reflective comparison of legal institutions is a means of acquiring new insights about one's own legal system and the place of our legal institutions in global conversations about the extent and validity of norms. But before we can further explore some of these exciting possibilities, we first need to understand whether comparison is possible at all. The question of whether any meaningful comparison and assimilation of constitutional ideas is possible lies at the core of a debate in the second half of the 20th century between Alan Watson and Pierre Legrand, which turns on appreciating the place of law within broader social structures. In his famous work titled Legal Transplants: An Approach to Comparative Law, Watson examines the migration of Roman civil law across several European legal systems. He claims that legal transplants, which consist of transferring rules between legal systems, are the primary instruments of social change. In light of overwhelming evidence of the widespread transfer of rules, Watson concludes that there is no close relationship between the legal rules and the society within which they operate. But as with the surgical procedure of organ transplantation, this account requires us to raise some more questions. For instance, is the donor organ compatible with the recipient? Does the recipient have the necessary supporting organs and blood vessels to facilitate a transplant? Is the surgeon capable of performing the transplant effectively and successfully, so on and so forth? In a famous response, Legrand suggests that Watson reduces laws to bare propositional statements devoid of historical, political, and ideological context. He argues that interpretation is in fact a particular understanding of a rule influenced by a series of factors that go far beyond the simple text of a legal proposition. According to Legrand, we are better off identifying differences across legal systems instead of similarities, which simply cannot be reconciled across diverse legal systems. However, the assertion that laws change when they migrate from one to another context does not and should not lead to the conclusion that transplants are either impossible or unworthy of scholarly attention, especially when the migration of constitutional ideas is as far-ranging as we have seen so far. For the comparative project to be worthwhile, it would require us to identify our own assumptions while studying other legal cultures, refrain from projecting our situated impulses onto the subject of our attention, and decenter our personal points of view in order to be able to appreciate the new and different in a meaningful way. We must be able to move back and forth between the text of legal rules and their application in particular contexts without immersing ourselves solely in either in our endeavor to compare meaningfully. Even if it is possible to compare thusly, albeit with due care and attention, why must we compare? Rand Herschel identifies three primary motivations behind an exercise of comparison, namely necessity, politics, and inquisitiveness. Let us briefly discuss each of these. We start with the first, necessity. For over 2 millennia, humans have had to think about how best to organize themselves in political communities. Along the way, they have had to think about how best to accommodate the diversity of their population. They have had to think about how to delimit the scope of the relationship between the citizen and the state, how to think about the checks and balances that need to be put in place to prevent the abuse of power, so on and so forth. The task of addressing these questions that we are facing right now will be well served by looking at the experiences of others in resolving similar dilemmas. An example of this kind of motivation, the motivation of necessity, is what we discussed earlier on in this module about the National Legal Services Authority case regarding the rights of transgenders. The second and related motivation is ideological outlook. Our own constitution is born from our drafters' appreciation of the promise of a Bill of Rights from the United States of America as a foundational aspect of a liberal democracy, while recognizing the need for a unique socialist method inspired by Soviet Russia that could capture a model for redistributive justice that would effectively unify a fragile nation and correct the extensive inequality of income. Here, the use of comparative materials is driven by seeking to affirm an ideological outlook that the comparativist holds. The third motivation that Herschel explores is inquisitiveness or intellectual curiosity. These may simply be an attempt to better understand, as he says, a general logic of matters. The best explication of this method is the groundbreaking work of Elkin, Ginsburg, and Melton, who attempted to identify the causes of constitutional endurance from an institutional perspective. Using cross-national historical data surveying every constitution drafted since 1789, they found that certain aspects of constitutional design could potentially lower the risk of constitutional death. A conclusion of this sort would never have been possible were it not for an inquiry whose scope was as vast as this. Now that we have identified some of the motivations behind comparison, let us preliminarily discuss the modes in and through which comparison takes place. A preeminent scholar of this field, Mark Tushnet, explored three predominant methods through which constitutional borrowing takes place: functionalism, expressivism, and bricolage. The functionalist case is premised on the fact that particular constitutional provisions facilitate particular functions in a system of governance. To these scholars, comparative studies perform the task of identifying those functions and illustrating how different provisions serve similar functions in different systems, or put another way, how similar provisions serve different functions in different systems. The functionalist may then be able to advocate alternate constitutional arrangements to improve the task of performing that function in a local jurisdiction. Under the expressivist view, constitutions emerge from the specific historical contingencies that shape a nation and uniquely vocalize the aspiration of its people. For these scholars, comparative constitutional law is a means of validating the precise nature of the cultural claims and directs our attention to an examination of our constitutional character rather than taking it for granted. Here, looking elsewhere is a means of re-emphasizing the culturally contingent nature of our own constitution. Borrowing from the anthropologist Lévi-Strauss, Tushnet identifies the idea of bricolage as the third mode through which the comparative constitutional law takes place. Bricolage is the assembly of something new from whatever materials are available at hand. Here, drafters select provisions almost as random from elsewhere. Somewhere else, Gunther Frankenberg likens this process almost to shopping for furniture at an IKEA stores, where customers can pick and put together parts as they see fit. Over the course of this module, we have explored different and at times competing rationales to understand the methods and motivations behind an exercise of constitutional comparison. As a student of this subject, we would resort to different methods, often one after the other, almost like a process of filtration, to best assimilate the teachings of other constitutions for our particular constitutional context. No one explanation can or will sufficiently surmount the challenges that comparison demands. An interesting and methodologically useful rubric that harmonizes our understanding is Sujit Chowdhury's idea of dialogical interpretation, where comparative materials operate as an interpretative foil that expose factual and normative assumptions underlying one's own constitutional order. Howsoever we wish to take this forward, Frankenberg's exhortation for care and sensitivity in our perspective will best allow us to use the experiences of others meaningfully. Over the course of this module, we have explored different and at times competing rationales to understand the methods and motivations behind an exercise of constitutional comparison. As students of this subject, we would resort to different methods, often one after the other, almost like a process of filtration to best assimilate the teachings of other constitutions for our particular constitutional needs. No one explanation can or will sufficiently surmount the challenges that this comparative project demands. An interesting and methodologically useful rubric that harmonizes our understanding is Sujit Chowdhury's idea of dialogical interpretation. Chowdhury invokes us to look at comparative materials and use them as an interpretative foil that exposes our own factual and normative assumptions and the assumptions behind the constitutional orders within which we operate. Howsoever we wish to take this forward, Frankenberg's exhortation for care and sensitivity in our perspective will best allow us to use the experiences of others meaningfully. Over the course of this module, we have tried to address 4 fundamental questions. The first was to understand how prevalent the use of foreign law materials is in the Indian context. So much so that it requires us inevitably to understand how other legal systems operate and better understand how we can use the materials and findings and understandings of other constitutional contexts in our own situation. Next, we went on to ask ourselves whether it's possible for this task of comparison to take place and came to the conclusion that it is in fact possible for the comparison to take place, except that it requires us to be careful of the culturally specific context within which the constitutions operate. After we figured that it's possible for comparison to take place meaningfully, we went on to understand what the primary motivations behind comparison usually is. And we found that three motivations operate more strongly than all others. The first is the motivation of necessity, the second is the motivation of political ideology, and the third is the motivation of inquisitiveness. Over the course of this module, we have tried to explore four interrelated areas. We first began by attempting to recognize the influence of foreign legal materials on the Indian constitutional context, and after understanding how prevalent and how widespread the use of comparative materials in the Indian constitutional jurisprudence is, we began to realize that we need to undertake a more serious examination of foreign materials and understand how best we can apply these other foreign materials in our own context. In the second part of our exploration, we asked ourselves whether it's possible at all for constitutional comparison to take place, and came to realize that it is in fact possible if we take care to make sure that culturally specific contexts are accounted for in our comparison and in our account of the use of foreign legal materials. In the third portion of our conversation, we identified three motivations behind the task of comparison: the motivation of necessity, the motivation of being driven by an ideological outlook, and third, inquisitiveness. In the last section of this module, we explored how these motivations play out in different modes of comparative constitutional law. We explored three predominant modes of doing comparative constitutional law, namely functionalism, which is focused on the function of specific legal provisions; expressivism, which takes into account the constitutional context of different legal systems; and third, bricolage, which recognizes that certain legal systems may be nothing more than a simple hash of available constitutional ideas. While we closed out this module, we recognized that we need to be careful and sensitive to difference as well as similarity across legal system if the task of comparison is to take place meaningfully. Thank you.